following program on Ada Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the intricate laws present to protect the fundamental rights of the freedom of expression and where it comes into contention with the core values of Sri Lanka. Quite recently, the whole country witnessed the controversial remarks of a YouTuber on important relics related to Buddhism. Questions have been raised about what exactly is the law behind this. Is Sri Lanka protecting its heritage via current laws, or is it damaging? How can the freedom of expression and speech be better understood? What are the key loopholes that need to be addressed moving forward? Alright, welcome back to Lawline and Liberty, where we are keeping with the promise of keeping with a contemporary legal topic, breaking it down for our viewers and giving the most up-to-date relationship with the law and what exactly is happening in and around the country. Now today's conversation will touch on a specific area, but within that area we'll have to go into many segments. And that is primarily because of the sensitivity that this specific subject has, and it is in relevance to the freedom of expression. And to discuss this, I have with me senior lawyer, President's Counsel Jagath Wickramarathne. It's truly an honor, sir, to have a conversation with you today. And I'm sure all of our viewers will get a very good breakdown, and there'll be a lot of things that we can learn from you today. So as usual, what we do within this program is we give a breakdown, as in the topics that we'll be discussing, so it's easier for our viewers to keep up with what we will be discussing. So firstly, we are going to talk a bit about the ICCPR Act. Now, that is the most fundamental piece of legislation that we'll be talking about within this field, and based on that, we see there are constitutional segments, constitutional provisions also that have been given that we need to cover. Secondly, we are going to talk a bit about the protections and the charges that have been present, as in the kind of penalties that are available when we are looking at the freedom of expression, and primarily when we are looking at the freedom of speech. And finally, we are going to talk a bit about the reformation aspect and the kind of remedies that are available.
Hello, my name is Ayush. I am an international sales manager. My question is on the ICCPR Act. What are the key features of the ICCPR Act and how it is applied in Sri Lanka?
Alright, let's get into the conversation directly then. President's Counsel Jagath Wickramarathne, thank you again for giving us this time. As I mentioned within our introduction, pretty much a sensitive area that we are going to talk about within this segment. This is why we went for one of the most senior lawyers present who can give us a breakdown on this. The fundamental legislation that we see is the Constitution, actually, even prior to the ICCPR, I should say. That is Article 14 and the limitations under Article 15, subsection 2. Where would you begin in terms of entering this? Will you begin from the ICCPR Act, because that is where we agreed on the international stage to a certain level of, I guess, a relaxed sort of method of approaching freedom of expression? Where would you begin in approaching this topic?
Danny, it's like this. I think before we get into the local legislation, we need to look at the background, as background to the ICCPR, the international convention.
Is it how it was enacted?
And yes, and also how it developed over the years. Even the Article 19, how it developed, how the freedom of expression was recognized by the international arena, right? The international, or rather the United Nations. Yeah. So we need to look at all that before we get into the ICCPR Act locally. Yeah. So when you look at what happened during the Second World War, I think subsequent to the Second World War, the nations of the world recognized, or they rather they identified, they understood the need for the human race to have certain restrictions in discrimination based on race, based on nationality, that kind of stuff became the subject of discussion. So as a result of that, the freedom of expression was one of the very fundamental rights, the fundamental liberties, which is you can even say that that's the cornerstone, or rather the foundation of all other human rights. Yeah. So the recognition was given to the expression of the freedom of expression. So that is where we need to start with.
Right.
Right. So then, when you go further, the freedom of expression, as I said, which is the foundation of all other liberties, all other human rights, and also the foundation of a democratic society. You can even call it, I have seen the writers say, it's the lifeblood of democracy.
Right.
So the freedom of expression is something where the world recognizes, or the society recognizes, the human's right to express himself.
Yeah.
In many ways.
Yeah.
It could be, like rather receiving or imparting information, or expressing yourself, expressing your opinion, getting involved in a democratic kind of a government, by way of discussion, all that. So whatever that you name it, which will come within the interpretation of freedom of expression. Yeah. So this freedom of expression has to be protected. Okay. So the international, or the ICCPR, or you call it International Covenant on Civil and Political Rights, that's a convention that the world or the United Nations started deliberations in 1966, but which came into force in 1976. So it took 10 long years for them to introduce or bring it to the force within the United Nations.
Yeah.
So then what happened was, the member countries had to ratify, if that was required, once they became a signatory to the covenant, the international covenant. So in Sri Lanka, though we have recognized certain parts of ICCPR, we became a party to that in 1980, though it came to being in 1976. So we became a signatory in 1980, but certain parts of the ICCPR, the convention or the covenant, the international covenant, were not introduced by legislation in Sri Lanka.
Right.
So in 2007, by Act number 56, they introduced certain rights that were recognized in the ICCPR by way of legislation. So now the problem is, we have actually, if you look at the ICCPR Act in 2007, you get a lot of, it's not only about this section 3. It has many other rights. It has established, it has recognized many other rights. But unfortunately, we at the moment, as I can see, we are using only this section 3 of the Act.
Right.
That is also for different reasons, so we will discuss that when we get into that subject. So that's how the ICCPR Act came into being in Sri Lanka in 2007.
Right. If I can just developing on what you're mentioning, I think it's interesting when you mentioned that we are currently focused only on one section within the 2007 Act. If you can just explain a bit further on that, and also if we can just touch on the constitutional provisions. Now, it's more or less clear cut within the Constitution, but still to this day we see that there is a certain confusion, a contention that occurs that needs to go to courts, and we were also talking about this prior. There was an entire conversation happening within our country also a short while back. Why is there that, I would say, that the lack of clarity there? Is it that much of a vague statement?
It's kind of funny, Danidu. Right now, when you look at ICCPR, the International Convention, I would like to take you through the preamble. Right, just a few probably a minute or so.
Sure.
So it says, in the preamble it says, considering that in accordance with the principles proclaimed in the Charter of the United Nations, recognition of the inherent dignity and the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. That's how it starts. That's how the preamble starts. It goes on saying, recognizing that, like I'm actually leaving certain parts out. The ideal of free human beings enjoying civil and political freedom and freedom from fear and want can only be achieved if conditions are created whereby everyone may enjoy his civil and political rights as well as his economic, social, and cultural rights. So considering the obligation of states under the Charter of the United Nations to promote universal respect for an observance of human rights and freedoms, agree upon the following articles. Right. So this is what the preamble of ICCPR says.
The objectives, basically.
The objectives. So it's, when you look at that, you can understand, the idea of getting member states to become party to this covenant, the international covenant, is to ensure the freedom of expression, the other liberties, and also to create an environment where every human being will respect the other human beings and the human dignity.
Yeah.
So that's the foundation. And when you go to Article 5, because we are actually the Article 3, or rather the Section 3 of our Act based on Article 20.
So, right, what you're referring to now is not the 2007 Act, but the original.
Yes, I'm referring to the International Covenant.
Right, okay.
Right?
Okay.
So, when you look at Article 5, this is where we missed.
Right.
Article 5 says, nothing in the present covenant may be interpreted as implying for any state, group or person any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms recognized herein or at their limitation to a great extent than is provided for in the present covenant.
Right.
So, what is meant by Article 5 is there may be certain restrictions.
Yeah.
There may be certain obligations cast on the member states, but it does not, or it should not be interpreted to say that it prevents or it suppresses the freedom ensured by the ICCPR Act itself,
right,
or the covenant itself.
Right.
So what happened was we have missed this Article 5. We don't even.
Why do you say we have missed it?
Because we haven't recognized, we haven't stated anything that is stated in Article 5 in our Act.
Okay.
Instead, what we have done is, there are two parts in Article 20. We have captured both parts very nicely and put it in Article 3. And the article, or the Section 3. The Section 3 says, no person shall propagate war or advocate national, racial or religious hatred that constitutes incitement to discrimination, hostility or violence.
Right. I think that's a very interesting point. A lot of people wouldn't have seen that side of it, so the way you framed it was very important there. A lot of questions that I have to ask you right now, President's Counsel, but we have to take a very short break given the time constraints, and we'll revisit this subject again within our next segment also. You're watching Law, Land and Liberty. Stay with us as we continue this conversation with President's Counsel Jagath Wickramarathne.
My name is Imangsi Senarat and I'm a student of Sri Lanka Law College. My question is on limitations to the freedom of expression. What are the key limitations as to the freedom of expression and how has it changed over time?
Right, welcome back to Law, Land and Liberty. We are in conversation with President's Counsel Jagath Wickramarathne. So I think I just want to make a comment on the way you're framing a lot of these issues is very vital, I guess, and it puts into perspective even for myself something that most people would think is a general topic that everyone knows about when it comes to freedom of expression. But let's just dive deeper into that, and within this segment I want to talk a bit about the limitations that are present. But I have to remark that you give a lot of emphasis to the ICCPR Act as opposed to, in general, lawyers would go for the Constitution and mention the provisions there. Is there a reason that you believe this empowers in that scenario, or the provisions here are more detailed?
No, actually, the issue, Tanidwi, is the freedom of expression is a fundamental right enshrined in the Article 14(1)(a) of the Constitution. So it's guaranteed by the Constitution of the country. So if there is any kind of a violation as a result of any executive or administrative action, then you have a right to go to the Supreme Court, file a fundamental rights application and challenge that.
Yeah.
The issue here is why I wanted to make more emphasis on the ICCPR Act was I have seen in the recent past this ICCPR provisions, or rather the Section 3 of the ICCPR Act is being used to suppress the dissent and also suppress the right of the freedom of expression by certain government parties. So this is something that you need to stop.
Right.
So we need to discuss this as to how the ICCPR Act, which is brought into force to protect the rights of the people, are being now used to suppress the rights of the people.
Right.
So that is why I paid more attention to ICCPR Act. But when you look at Article 14(1)(a), as we all know, the freedom of expression is guaranteed as a fundamental right.
Yeah.
But there are certain limitations.
Yeah.
The limitations are legally described in the Constitution itself.
Right. Under 15(2), that is.
Under 15(2).
Yeah.
So 15(2) says, so it has, the certain restrictions can be imposed in relation to or in the interest of racial and religious harmony, or in relation to parliamentary privileges, contempt of court, defamation or incitement to an offense.
Yeah.
So those are the only restrictions that you can impose in some person exercising the right to freedom of expression. So otherwise, freedom of expression is a fundamental right that is guaranteed by the Article 14(1)(a), and you have to give that freedom, you have to give that liberty to the people of the country.
Yeah.
So these are the only restrictions that you can impose. Now, even if you look at the ICCPR, the International Convention, Article 19 is the article that deals with freedom of expression.
Right.
So the Article 20 is the article which gives the member states, or compel the member states, to proscribe any propaganda for war, and also advocacy of national, racial or religious hatred that constitutes incitement to discrimination, hostility or violence that has to be prohibited by law.
Right. Just to bring this back, what you mention is that was not entered within the 2007 Act, or have we made inclusions of that within our Act as well?
No.
The limitations?
No.
Right.
The problem is our Act only speaks of Article 20.
Okay.
But most of the writers, if you look at the writers who have dealt with the Article 19 and 20, they say the Article 20 is in fact the expansion of Article 19.
Right.
It's the fourth limb of Article 19.
Right.
So without talking about freedom of expression, or without paying attention to the freedom of expression, you can't actually deal with Article 20. Okay. But unfortunately, in our Act, we only speak of this Article 20. Okay. So that is how, or that is where things have gone wrong for us. Okay. And now the police, even in recently we saw one of the writers, I think Shaktika Satkumara, right, who had write an article or write a short story, write a short story, and a certain Buddhist priest had gone and complained to the police, saying that I think he has said something against Buddhism or something like that, and he was immediately arrested, and he was in remand for 130 days. Right. And after that, the Honorable Attorney General decided that there is no basis whatsoever to file action against him. Right. So he had to spend 130 days in remand merely because he has expressed himself. Right. He had just written a short story. So if we are going to control all that, if we are going to suppress that, I don't think that is the intention of ICCPR Act.
Right. I think there is an entire conversation about the PTA there also, and that is also another subject I guess we'll have to talk for another entire day on. But since we went to the subject of the kind of claims that are being made and the kind of charges that are leveled, where does not the burden actually, where does it fall in favor of the people that are charging? Like, what are the places where the freedom of expression now, anyone can generally go over the Constitution, and the Constitution would give a very, let's say, vague understanding of this. But where do you see concrete charges being leveled against an individual? What are the kind of charges that can be actually imposed by the police in a court of law and really extended against the person? Where does that conversation come in?
Actually, the Human Rights Commission of Sri Lanka was very proactive.
Okay.
Right? In fact, they gave a guideline. Okay. They gave a very clear understanding of Article 20 of the International Covenant, and also, that we need to interpret, or we need to look at Section 3 of our Act in the context of Article 20 in the International Convention. Right. So if you look at, actually this was not only an issue here, this became an issue in certain other countries as well. Yeah. So lately, they had to develop a system, or rather a test, that has to be applied if you try to charge somebody under the Article 20 of ICCPR International Convention. Like no one is going to charge under the International Convention, but it has to be under our Act.
Yeah.
So if you are seeking or if you want to charge anyone under Section 3 of the Local Act, Act number 56 of 2007, you have to apply this test.
Right.
So this is, when you look at it, it's very clear. The Human Rights Commission had said.
So just to clarify, our courts have adopted this test and this is considered the way to go move forward, or is it what the Human Rights Commission suggests?
No, actually it's little bit it's premature.
Right.
Still we have not gone into all these things in court.
Right.
But the Human Rights Commission had specifically stated that, and in fact the Human Rights Commission in 2019, as far as I can remember, I think I brought those letters, yes, on the 29th of August 2019, wrote to the Honorable Attorney General, wrote to the IGP in relation to people being arrested under Section 3 of the ICCPR Act.
Right.
So in that, the Human Rights Commission had referred to a plan called Rabat Plan of Action. Okay. That's actually the the United Nations Office of, I think, Human Rights. The United Nations developed a developed a 6-stage kind of a test,
okay,
which took 4 years for them to develop.
Right.
So in that, they say the first you need to see the context in which a particular statement has been made. So that is the context. So you look at the political, the economic situation of the country, in what context the statement had been made.
Right.
So before you charge somebody.
Okay.
Then the second one is the speaker. Whether the speaker has some kind of a, whether he is in a position of an authority, okay, where he can influence people.
Right.
Merely because you write an article,
yeah,
right? You have no intention whatsoever to discriminate or to attack any religion or nothing like that.
Yeah.
You just express out of your creativity. You write a short story.
Yeah.
So this is not an act where you can charge a person, a writer, for doing that.
Yeah.
So you have to look at the context first. Then you look at the speaker. You see whether the speaker has that position of authority in the society, whether he wields influence over the audience. So that's the second test.
Yeah.
So the two parts. Then the third one is you look at the intention.
Okay.
So intention is very important.
Right.
So you look at the intention to see whether he has the intention of discriminating or rather attacking or spreading religious hatred.
Anything within that framework.
So
yeah,
then you go, after that you go to go and see in what form, right? So mode of expression used, whether the intention of that particular person is to basically spread the hatred,
yeah,
among other people.
Yeah.
So that is then the extent of the advocacy.
Yeah.
To what extent? The public nature, the magnitude of the statement, that kind of things also will be looked into.
Right.
Then you go, then you see whether there is an imminent harm,
okay,
that will be caused as a result of the statement. So when you look at all these things, this is the test that you apply.
Right.
So you apply these tests and see whether in fact there is a situation that you can charge a person under the Section 3 of the ICCPR Act.
Right.
So if you can't satisfy the test, then you can't charge that person.
Right.
So it's very clear, because this is a test internationally developed. The United Nations developed this test purely because to prevent the member states using the particular covenant or the particular article to suppress the dissent.
Right. Just going along on those lines, President's Counsel, I want to just get a clarification on the aspect of now. I think we can't not reference the PTA when we are having this conversation. So just to reference that a bit, the world at large takes a stricter role on terrorism. We have seen it, and this the issue of charges being leveled against an individual has come up. It has been debated a lot, but it has come up because that arbitrary nature is sometimes required when it comes to matters related to public security and national security. How do those things tie together? Now, this is I think the most sensitive area within this subject, about how the law enforcement can carry out their own duties at the same time protect these fundamental rights that people need to be awarded in a working democratic country. how do you see that entire question?
No, there's no question. The entire world is looking forward for ways to combat terrorism.
Yeah.
So we need to support that. There's no question about that.
Yeah.
But this PTA, the provisions of the PTA, takes most of the rights of the people away.
Yeah.
Right. So now that is the issue with the PTA.
Yeah.
So if you need to combat terrorism, the laws that is required for combating terrorism, you will have to bring that laws into force. That's no problem with that. But of course, the PTA, the draconian nature of PTA, right? So you don't have the usual rights that you exercise under our laws, right? When you are charged for any other criminal offense, the right that you have to go before court, you can keep people in detention for long periods of time. So all these things became an issue.
Yeah.
So that is the problem with the PTA.
Right. So I think that clarifies sort of like the different elements that are present with the PTA and pertaining to freedom of expression. Also, we'll take a very short break. We have. I want to get a proper understanding from you about where we can do this reformation process in order to fit all of these things together. We are in conversation with President's Counsel Jagath Wickramarathne. Stay with us as we continue on Law Line.
Hello, my name is Minitha Perera and I'm an HR executive. My question is on reforms. How should the law governing freedom of expression be reformed?
Right, welcome back to Law Line and Liberty. We are in conversation with President's Counsel Jagath Wickramarathne. Two very important segments that we just passed pertaining to a wide variety of things about the freedom of expression and then tying it down to freedom of speech. Now, just to something that I think I've never heard in most of these conversations is the 6-part test, if I'm not mistaken, that has been proposed, and I think that is essentially something we need to be considering when moving forward on the conversation of the freedom of expression. Mr. Jagath, how do you then look at the reformation aspect that is required to bring most of this to 2023? Now we see that the conversation of freedom of expression, if we leave out things like the commercial aspect of things, where there's one would say a lot more developments that need to happen. We assume that the freedom of express, things like fundamental rights, have been covered, and the Sri Lankan law is, somewhere there where we can move forward with that. What we have right now, is that the same way you would see it, or where do you think the developments need to happen?
No, I think the first thing that we need to understand the real nature of ICCPR, the International Convention, and the reasons as to why the International Convention came into being. So without studying that, without having kind of a proper understanding on that, I don't think we can make use of the law that we have introduced to this country as far back as 2007.
Right.
So all these acts, all these statutes, and also the international covenants, so everything is aimed at one thing, that is to protect the freedom and the liberty of the human race.
Right.
It could even extend to other animals as well.
Right.
So the first thing is we need to understand that. I think the point that we have missed here is we do not give any kind of a recognition, or we don't give due regard to those concepts internationally recognized. So the first thing is, now if you look at the section 3 of the Sri Lankan Act, or rather the Article 20 of the International Convention, the intention of that is not to prevent people from sharing their opinions. That's not at all the idea. The idea is to stop people compelling others to commit certain acts in advocating national, racial or religious hatred. So that's the idea. So if we are going to use this only for that particular purpose, where someone is making presentations or speaking at public the seminars or something like that, spreading hatred against a particular nation or a particular group of people, we say a religious group or whatever it is, then certainly we need to make use of the provisions. So the way forward should be, I don't think we need to be worried about the laws that we have here.
Yeah.
The law is good.
Yeah.
The law is sufficient. The usage,
of
the manner in which we use that law is where things have gone wrong for us.
Right.
So we need to put that in the proper perspective in order to achieve what we intended to achieve by introducing the law into the country.
As you explained that, President's Counsel, if you can touch on the penal code as well, because now the issues now, since we generally talk to an audience of laymen and law students, we generally see a comment being made and then that comment being held, either charges being leveled against that person who has made that comment. But we are unclear as to what the provisions are that actually talk about these things, because if it's not a defamation case, if it's not the usual issues that we would notice, where a position of authority or even a contempt of court, that is what I was looking for. What are the other areas? Are there other areas that you can list out and say, okay, these things are mentioned in the penal code that you cannot do? Or is that also something that we need to really reform, we need to improve on?
No, more than paying attention to the penal code, Danidu, we need to pay proper attention to the ICCPR Act.
Right.
So because the ICCPR Act is more dangerous.
Right.
So if you are using it for the proper perspective, in the proper perspective, for the proper thing, for the correct thing, it's a very good act.
Right.
You can achieve a lot of things by this particular statute. But if you're going to misuse it, because I'll give you one example. Now, usually, if you have committed any offense under the penal code, you can get bail from the magistrate's court itself.
Right.
But under the ICCPR Act, if you are a suspect, if they are going to charge you under the ICCPR Act, the bail could only be granted on exceptional circumstances by the High Court. So it's a difficult process.
Right.
It takes a lot of time.
Yeah.
So that's what happened to Shaktika Satkumara. He was in remand for 4 months,
right,
from 1st of April, as far as I can remember, till 5th of August. Okay. He was in remand. So you have to, the remand prisons of this country or any country in that sense, I don't know. I don't think you get all these facilities. Anyway, you're restricting the civil liberty. Yeah. A person to live with the family, yeah, a person to walk out in the society, wherever that you need to go, everything is restricted. For what? If you have done something illegal where you can be charged, and until and to the extent that is required, where you need to be the remand, keeping your remand is something else. Yeah. I'm not talking about that. Yeah. But all what I'm saying is, merely because you have expressed yourself, yeah, merely because you thought that you express your opinion, yeah, right? So which has absolutely nothing. You have no intention of discriminating, or you have no intention of advocating national or racial or religious hatred. Yeah. No, nothing like that. You don't have any intention at all. Yeah. But merely because you have expressed yourself, or you being creative, yeah, and you are being charged under the act. So that is wrong. Yeah. So this is actually, if you look at this document prepared by the Human Rights Commission, it's a very good document, right, where they went to the extent of giving examples for what kind of acts, for what kind of situations you can actually use this. I can even read one or two for you. Sure, yeah. It says, in encouraging, directing, or instructing the public to attack a person of a protected group or an individual of a certain nationality, race, or religion. Right. So you are virtually lining up people, yeah, or you are encouraging people to go and attack a group of people or an individual based on his race or based on his religion. So things like that, if you are doing it, certainly you are a person that has to be charged under Section 3 of this Act. There's no question. Yeah. They say provoking destruction of religious sites, property and livelihoods of protected group. Right. You select a particular group. Now, if you look at in the international arena, there's a case called Ross versus Canada. Right. A teacher in the government, in one of the schools in Canada, he was propagating, he was advocating hatred against the Jews and the Jewish religion. Okay. So then, as a result of this, Canada took steps and removed him from his office. as a teacher.
Right.
Because his speeches came on, I think, certain pamphlets and things like that. So he was removed. So thereafter, he challenged that, I think, in the domestic courts where he failed, and he went to the International Human Rights Commission.
Okay.
So in the Human Rights Commission, they said, by looking at it, having analyzed everything, what he was doing was spreading hatred based on the Jewish religion.
Yeah.
Right? So that kind of thing, where you compel other people, you encourage other people to go and, so it's a massive thing that you're doing.
Yeah.
So you look at the magnitude of what you do.
Yeah.
So because of that, they said, no, you can't actually have any kind of a protection under the ICCPR, the International Covenant.
Right.
So that is a situation. So that kind of a thing you need to combat. You need to stop that. You have to prevent it.
Yeah.
That is in order to maintain the peace and the give due dignity and regard to everybody, every human being.
Yeah.
So that's the intention of this act.
Yeah.
But we're using it for something else.
Right.
So more than talking about bringing in amendments or amending this, there's no need. You only have to make sure that it is implemented properly.
Right. As a final remark, if I can just ask you, President's Counsel, I think your experience is far wider than the question of freedom of expression, so I want to really pick your brain on those things as well. Now we see issues of defamation, we see issues of where the freedom of expression is involved. Now there are sensitive subjects again, where both sides can be considered. The media, in a certain way, I think I'll be biased towards the media in this scenario, but has a format of ethics. I think you have spoken about this as well. But we see novel sort of social media sites that are coming up. And the capacity to maybe not control, but regulate the kind of expression that happens there, it's becoming far difficult. In such a society, do you believe the ICCPR still, as in I believe that you have been quite favorable towards the aspect of expression, and I think I also fall into that category. But do you think we need to improve since the platform or the windows have become so far wider in this subject?
That is, I'm a believer of self-regulatory system when it comes to media. So because as you know, the media is treated as the fourth pillar of democracy.
Yeah.
So if you think or if someone is trying to get the government to come and regulate media, that will definitely create chaos.
Yeah.
So you have to keep the media freedom as it is, because that's something required to ensure the democratic values in the society. So the issue is now the way the social media being used. Now I personally think it's good that you asked that question. I personally think a person with a self-respect might not even get involved in politics, because you get involved in politics today. I don't know if somebody asked me whether I'm interested in getting involved in politics. The way the media being used at the moment to attack people, I probably would say I don't want to get involved.
Yeah.
Right? So no person with dignity and self-respect in the future might get into politics. So we have a problem.
Yeah.
So we have a problem, we need to address it. But that doesn't mean that we need to have a government, somebody or the minister or someone appointed committee to regulate the media. So the self-regulatory system in relation to media is what we need to promote. Right. So I'm actually a propagator of that. I'm promoting that.
Yeah.
So that is what we see. So if you think the self-regulatory system, it's actually happening in the country at the moment.
Yeah.
The Broadcasters Guild, they have got together, all the broadcasters, including your organization. I think everybody is in that. So they got together and they're trying now, they have already started working on it.
Yeah.
They're trying to introduce a self-regulatory system for all electronic media organizations in the country. So that's a good thing.
Right.
So if that does not really work, we need to try that first.
Yeah.
We can go for co-regulatory system, co-regulation.
Yeah.
So other than that, going beyond that, I don't believe in that.
Right. I think there are a lot of other things that we can speak to you, Mr. Jagath, but I think time has, as usual, come against us within this program. But a very interesting conversation, and I think even I got together a lot from a topic that most would assume that they know a lot about. President's Counsel Jagath Wickramarathne, thank you so much for spending the day with us on this specific subject and really explaining something that's very important. All right. The laws that protect the freedom to express should be both considerate and strict for the growth of a country in a direction that is suitable for all citizens. Chinese activist and author Liu Xiaobo once said, "Freedom of expression is the foundation of human rights, the source of humanity, and the mother of truth." That is all from us here at Law, Land and Liberty. If you had missed today's program, you can rewatch the entire episode on our YouTube channel, youtube.com/othertharenenglish. I'm Daniel Tanvasa. Have a great night.